Well, sometimes the court has to consider what the citizens and the community partners, what they have observed, what they know, what they have experienced, that they have interacted with Ms. Hawkins. This court, obviously, it's been very limited. The court has interacted with Ms. Hawkins. I do believe that Ms. Hawkins has great remorse for what occurred. There. The defendant's attitude was cooperative through the interview process for the preparation of the pre-sentence investigation report. Ms. Hawkins has served 345 days as of today's date of June 17th, 2026, for which she's entitled statutorily to credit against any sentence imposed. The family history: Ms. Hawkins was born on May the 22nd, 2000 in Brown County, Ohio, to Karen Sue Hawkins and Scotty Stanford Hawkins II, both of West Union, Ohio. She currently resides in West Union. The defendant has two biological siblings, with the defendant being the second of the siblings born. Her parents have never been involved with law enforcement interaction. She rates her childhood overall as good, with no history of abuse or neglect. She has never been married, not currently in a relationship, has three biological children, with Jason Burkhart being the father and being in foster care placement. Aurora, 6 years old, Lila, 3, who's now deceased, and is does not show a pattern of drug use related to this offense. And lastly, the question of whether she has genuine remorse for her actions or for lack of actions, in a sense, in this case. They do say, the assessors do feel that she shows genuine remorse. She scored 10 or low on the Ohio Risk Assessment System, indicating a low risk of reoffending. She's never participated in substance abuse treatment. Her employment history is admirable. She has utilized her certification in culinary certification and Serve Safe in her food and beverage training. She has been a manager at both McDonald's and KFC Taco Bell. At McDonald's between the periods of June 2023 and June 2025 for in essence a 2-year period. At KFC from August of 2018 until June of 2022, a 3.5-year stint. And then in between, she worked with Subway as a line manager and cook. She reports currently having no monthly income or expenses, that when she was employed, she could pay her bills. As most adults, she sometimes worried about her finances and struggled to make ends meet. But otherwise, she was able to manage her debts. Recidivism, as to whether it appears based upon the assessments whether she's likely to recommit offenses, criminal offenses, it rates as low. The court notes that, and had earlier noted that it did receive and reviewed letters from a former Sunday school teacher of Ms. Hawkins, who has stayed involved in her life to the extent that she could, always showing, I guess, structure and mentorship, and also she indicates that Ms. Hawkins was always receptive and always kind and respectful to her children. There's also a second letter from the sister who sets forth her relationship with her sister. And then there is a Mr. Fox, or Jesse Fox, he or she, that gives a statement of credibility in regard to Ms. Hawkins. And then lastly, there was documentation received that during her 345 days incarceration that Ms. Hawkins has been a model prisoner for the Adams County Sheriff's Department, and that she's also seems to, it's joined in that there is remorse that's shown, that she carries a folder with the pictures of her children with her and often refers to them. With that said, the The and so that's the court's concern, and then also how the child ended up. And I realized sometimes children sleep naked, but there was just no guardrails there. And I ask in cases sometimes, would you go to the grocery store and sort through all the apple bin and pick out the bad apple and bring it home to your children? And mothers always say no. But you sorted through the apple bin and found this Brian Mosier, bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. And I struggle with that. Do you want to comment on that? You don't have to. Court that the court, with some hesitancy, but finalized that after due consideration, the court finds the defendant is not amenable to available community control sanctions. The court does intend to follow the stipulated prison term, and it will be imposed that the defendant shall serve the stipulated prison term in count 3, of 30 months, a stipulated prison term in count 5 of 30 months, which shall be served consecutive to count 3, and a stipulated prison term in count 7 of 30 months, which shall be served concurrent to counts 3 and 5 for a total of 5 years incarceration in the Ohio Department of Rehabilitation and Corrections. Because multiple prison terms are being imposed on Ms. Hawkins for convictions of multiple offenses, the court may require that she serve them consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct or the lack of conduct and to the danger that it poses to the public. And the court makes the finding that at least 2 of the multiple offenses, in this case 3 offenses, that 2 of the multiple offenses, at least 2 of them, were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed is so great or unusual that no single prison term The court finds that the defendant's placement or transfer into a transitional control program under 2967.26 while incarcerated, or her placement or transfer into an intensive program prison under 5120.032, both are hereby specifically reserved by this court for denial upon notification that the Ohio Department of Rehabilitation and Corrections desires consideration of the defendant for transitional control or for the intentional program prison. The court finds no beneficial matter of imposition of a fine upon Ms. Hawkins in this case, and so there will be no fine placed upon Ms. Hawkins. Any money that she may earn through state pay, I hope she sends that back for the benefit of her remaining 2 children. The defendant is ordered, though, to pay all court costs of the prosecution of this action for which execution is awarded and any fees permitted pursuant to Section 2929-18A4 of the Ohio Revised Code. The Department of Rehabilitation and Corrections is ordered to withhold funds in the appropriate amount from the defendant's account to pay these most limited financial sanctions. Under Section 2947.23A1A, before I give the appellate rights, I'll start with the state. Do you feel that the court has complied with the stipulated sentencing agreement as presented to this court?
Yes, Your Honor.
Defense counsel, same inquiry.
Yes, Your Honor.
Very well. Ms. Hawkins, do you believe the court has imposed the sentence that you had stipulated or agreed to with the state of Ohio?
Yes, Your Honor.
Ms. Hawkins, this is now a final appealable order. You have the right to appeal this court's decisions, but you must do so in a timely manner. You must do so within 30 days of today's date, for I intend to sign this judgment entry of sentence today. As a United States citizen, if you cannot afford the cost to file that appeal, then you have the right to file that appeal free of charge. If the court possesses documentation that you need to promote your appeal of this court's decisions, then upon your request, again, the court will provide those documents to you free of charge. If you cannot afford the cost to hire counsel to represent you effectively, as the court firmly believes that both Ms. Carrington and Mr. Walker have done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you. But you will be required, Ms. Hawkins, to pay a $25 energy counsel fee fund. Ms. Hawkins, I stress to you and I emphasize to you, you must file that appeal within 30 days of today's date. Ms. Hawkins, do you feel you understand your appellate rights?
Yes, Your Honor.
Ms. Hawkins, did you understand that you must file that appeal within 30 days of today's date?
Yes, Your Honor.
Do you have any questions about your sentence or your appellate rights?
No, Your Honor.
State of Ohio, do you have anything additional or objections you'd like to have noted at this time?
No, Your Honor.
Ms. Carrington and or Mr. Walker, anything additional or objections you'd like to have noted at this time?
No, Your Honor. Thank you.
Ms. Hawkins, is there anything else you would like your counsel to bring to the court's attention before we conclude today's hearing?
No, Your Honor.